in New York City, while Cornell, also in New York City, but also in Qatar, we have a research enterprise of more than 1.4 billion dollars. So it's a lot. So it's a great enterprise that, in terms of research, that generate a lot of new innovation, and that innovation is split between 57% between Cornell in the different campus in Cornell Tech, and 43% at Weill Cornell in New York City and Qatar. So it's a huge enterprise that defines a little bit our activity at CTL. If we go to the next slide. And here was to show a little bit the distribution between the federal funding that we receive, that is almost half of what we receive for the research enterprise. So it defines, as I mentioned, the role that we have in our activity at CTL, because our mission is twofold. First, we are catalyzing any new technology, technology and commercialization that is being developed at Cornell. So the goal is to develop new products and services from the university research, and the goal is to have, hopefully, societal benefit and impact. And the second mission is to promote new technology ventures across the region, in New York City, in New York State, and also across the nation. And if we look at data that is important for us, for our activity, and for the university, that is important for the university, we receive a lot of new invention coming from you as a grad student, as a postdoc, but also as a faculty. We receive new invention disclosure, new disclosure from you. So if we looked at data from fiscal year 2024, we receive more than 300 new disclosure from you. And what we do with those new disclosure, and Martin later on will touch upon that, but in terms of metrics, we assess and we protect those innovation at a certain percentage. I don't know if it will address later, but we protect at least in terms of US, in the US, in terms of non-provisional for fiscal year 2024, we have in terms of number 169 US non-provisional patent application. We have secured 107 US issue patent. In terms of the flow in this commercialization, we have generated 109 license and option, and also secured 10 startups, which has generated across the overall activity at CTL 22 million in terms of revenue including licensing and royalty income, but also patent reimbursement. And all that coming from the research, as I mentioned, this research enterprise that is more than $1 billion. Next slide. Okay, so basically I mentioned our mission and how we implement that. We implement that through 4 pillars. So the first one is the gap funding. The gap funding program that we have. If you click on the next slide. Yeah. So basically, we try to accelerate the technology and to support new venture through those programs. And I will talk more about it in the next slide. And we try also to train entrepreneurs. The second pillar, the technology and licensing and IP, that Bill and Martin will talk more about, where we manage all the university IP and we support inventor and researcher. We are doing marketing and licensing. The third pillar, it's technology startup, where we have a fast track license, which is important because most of our new startups have a fast track license that has been developed by the BD team and the leadership to enable to implement quickly a startup and to spend less time negotiating and more developing the startup. We have also a lot of support that we provide to startup and to connect them to investor, but to help them build and grow their startup. And we provide a lot of, I mentioned, ecosystem support. And the last one, the education, the last pillar, education and outreach, like today, where we are trying to share the learning about IP, about commercialization, about new ventures. We have also an internship in CTL Practicum I will mention later. Let's go to the next slide. That one is a matrix that we want you to be aware that show our activity. I will pay more time on the education here because it show if you go under education, you can see we have practicum program and we have also event. We have generated more than 34 external outreach events, 70 office hours, and the office hour you can join anytime our office hour, and 14 internal outreach events, which are the training on the different, when I say the training on different programs, for example, to the practicant, the intern, but also to our Ignite Fellow. And I will talk about them in the next slide. Let's move to the next slide. And here I mentioned the support to our startup ecosystem and the fast track. And you can see in the past 10 years, you can see an exponential growth across the year since 1990. And over the past 10 years, it has accelerated particularly. And it showed that there are more startups being created based on Cornell IP, which is very positive. And here's in terms of metrics, during fiscal year 2024, we have created at least 7 startups has been created and formed. And in terms of active startup, we have 113 active startups. And during the fiscal year 2024, they have raised more than 400 million in terms of equity, in terms of convertible notes and grants, research grants. Next slide. Next. So here I wanted to show you our different activity based on the audience. So the Cornell innovator, and most of you are innovator in this room. So what we offer to innovator, we offer office different support and services, the office hours, educational programming. We offer also access to expert to the CIVA roundtable. We offer also grants to the Ignite Innovation Acceleration. And we offer also possibility to become co-founder to the Ignite Fellow. Next. What we offer to entrepreneur and startup, basically we have also the Ignite Fellow because MS, those who have an MS degree in STEM, but also have they have a PhD degree, they can become a co-founder through the Ignite Fellow program. It's an accelerator program. We have also the fast track that enable creating quickly a startup, at least launching quickly the startup and spending less time in negotiating. We have the Ignite Startup when the company is launched to receive some support to de-risk, continue de-risk and grow the company. We have Ignite Connect, which is an online event that we have to connect those participating in the Ignite community to connect with investor, and Ignite Showcase for those innovator, researcher who want to learn about the outcome from the different Ignite grants. Next. The student. For the student, we have the CTL Practicum program that we recruit students annually at the beginning of the fiscal year, and to help them have a different access to and understanding of commercialization. We have Ignite Intern, which is during summertime, and we have also different various educational programming. And the last one. And to the corporate and partner, we have different access, as I mentioned earlier, CIVA, where the innovators they present, but also they have access to feedback from the industry. Those industry will provide, get first look to what is the Cornell innovation, and they will provide their feedback. They have access to Ignite Connect and other events where they can start getting engaged with CTL. Next slide. So here, after showing the different activity, I want to spend some time talking about our commercialization process, because it starts with you doing the research, having an idea, and you can reach out to us anytime at the ideation level. Even you think you don't have an invention yet, you can reach out to us. And when you basically that process, you start by reaching out to us. You can disclose at any point. And I want to show this commercialization process to show you that at any point of time, you can reach out to us. And it's at the end, we want to generate impact. Can you go to the next slide? Thank you. And through this journey, commercialization journey, it's important to make sure that you understand what are the different steps. And it's why we have this event today. And it's why we have branded and revamped our programming, educational programming, for you to have access to a comprehensive and more integrated program that include understanding of IP, that include understanding of commercialization and venture, that include understanding of different topics such as healthcare, but also topics related to engineering, semiconductor as well, and also importantly, social science. So through this new revamped program called Lab to Impact, we want to make sure that you have an understanding of the IP and commercialization process. And we'll have 4 different modules that we'll offer over the year. And what will be important, you can pick and choose your module. We'll have that information at the beginning, and we'll display the different session for you across the year, and we'll be able to pick either IP or commercialization and venture, or all of them, if you feel that you are interested in all of them. So the goal is for you to really see the full journey of commercialization and to make sure that you are participating in it, and hopefully you will have a positive impact. Next. So I mentioned earlier the different program. Let's dive a little bit into specific of each program. SIVA. SIVA is a Cornell Innovation and Venture Advisor. And as I mentioned, for innovator, it's important for them to have an interaction, understanding of what the market is and what the experts are looking. And it's good for them to have access to insight from industry expert, but also investor. And it's what we offer to innovator for them to have those exposure to the SIVA program. Next. And the practicum is our internship program. We have great intern, graduate student, and postdoc intern. We had 14 during fiscal year 2024, and it's an internship of 9 months minimum. And we ask for a commitment of, as I mentioned, 9 months, but also 10 hours. It can be less than 10 hours depending of the other appointment from the graduate student. We have a formal onboarding because we want to make sure this is a win-win where we train you and at the same time you learn about the commercialization process, but also for us, we have a work product that will be able to leverage and be more impactful in terms of the work product and marketing work that we are doing. And we'll share with you the slide, and you can hear and read more about 2 of our practicant and former practicant, Olga and Andrew. Andrew has already graduated, and that both of them were fantastic practicant. You can read later what they share here. Next. And our Ignite Fellowship, we have a fantastic Ignite Fellow right now, Etienne. And basically, what is this program? It's a program where we hire a PhD graduate or postdoc researcher for up to 3 years, a year, 1 year old, up to 3 years. And basically, initially they have an interest in business development, commercialization, and they help the BD team with their marketing, their licensing. And it's a great experience when you just come out of the lab and you want an exposure full-time job that will provide an exposure to what is tech transfer And Tian was a fellow, was a practicant before, and now she's a fellow, and she's a great team member. And I'm sure you will hear from her in the future. Next. And let's take some time to talk about Ignite. Ignite, and I will be happy anytime to reach out to me if you want to hear more. Ignite program is a gap funding that support de-risking technology, and we have 4 series under this Ignite series. We have the first one, Ignite Innovation Acceleration. We provide a grant to researcher, and most of you are researchers doing research, so you have access to this grant. We have an application open right now, so reach out to us, to Chris on I, and we'll share the information with you. Ignite Fellow, it's an accelerator program where we recruit a PhD graduate that receive at least a student that just completed a PhD or master degree, and we recruit them, we pair them, if not already done, with a faculty so they can co-found a company. The goal of the program is within a year, you graduate from with a startup, a fully operating startup. Ignite Startup now, it's a program where we provide 50K in form of safe note to existing company that have already a license with CTR. And the last one, Ignite Intern, where we provide support of a Cornell student intern during summertime to existing licensee, startup licensee. Next. And lastly, I will talk about our team. It's important. So to do all those operations, we need a great team, and we have the leadership. Alice Lee, the executive director, and Lisa Plakanika, the senior managing director at CTL at Weill Cornell. Next. My team, the technology initiative, the title has been updated, the Technology and Venture Initiative and Engagement. My team is in charge of, as I mentioned, responsible of educational programming, the venture initiative related, and the gap funding program. Next. The IP management team that is led by Bill, with a fantastic team in charge of the patent management and the IP services. Next. And the BD team and licensing, and Martin will talk more about the type of work they do, particularly the assessment of all the new invention disclosure that they receive. And then we'll move to Lisa, who will talk more about Weill Cornell Enterprise Innovation.
Thank you, Linda. So as I mentioned earlier, the Center for Technology Licensing out in Weill Cornell Medicine campus is part of a larger initiative focused on healthcare innovation coming out of Weill Cornell Medicine and our sister institution in Doha, Qatar, called Enterprise Innovation. So CTL is the core group within Enterprise Innovation, responsible for intellectual property strategy, business development strategy, commercialization. And we do this through a variety of partnerships with commercial entities, whether they're research collaboration alliances or licensing and partnership with existing companies or launching new ventures based on Weill Cornell Medicine technology. We work closely with the BioVenture eLab, which, like Linda's group, provides core education programming and resources around entrepreneurship and matters pertaining to innovation and commercialization. Our version of the Ignite Fund is called the Daedalus Fund for Innovation. So this is an internal gap fund we use to help de-risk and advance commercially promising technologies toward commercial partnership. And we work closely with the TRI-TDI, which is a drug development engine in New York City that is in partnership with Weill Cornell Medicine, Rockefeller University, and the Memorial Sloan Kettering Cancer Center. And the scientists at TDI are medicinal chemists and biological engineers, and they work with faculty and trainees that have novel therapeutic target ideas to develop early stage drug programs. And so we work together in a kind of a holistic fashion to really just advance innovation toward commercial partnership. Next slide. So we have a team that's located here in New York City. So I'm Lisa Plakanika, and these are just some of the key business development licensing people. So we structure our office here that every department and institute and center at Weill Cornell Medicine has a point person within Enterprise Innovation that you can kind of contact at any time with questions or interest in learning more about how we can help support your translational research. Next slide. It's just more of the team. Lauren Busby is the director of the BioVenture eLab. So she works a lot with students and trainees and faculty on helping to kind of, give a new lens to look at research from an entrepreneurship perspective. Next slide. Next slide. We partner closely with Linda and her team on a lot of programming, which we promote at Wall Cornell Medicine. And in addition to that key programming, we also have specific programming here at the medical college. Most of it is open to anyone. You don't have to necessarily be affiliated with Wall Cornell Medicine. But all of our programming is looking at kind of healthcare innovation with that kind of lens. Some are even credit-bearing courses like Accelerating BioVenture Innovation and the Fundamentals of Academic Business Development, which is student-facing. But we also have faculty-facing programming such as the business plan pitch competition in the spring, in addition to just general interest topics that we host throughout the year. Next slide. I will specifically call out the Advancing the Fundamentals of Academic Business Development. This is a credit-bearing course in the Department of Pharmacology for Wall Cornell Medicine graduate students. Postdocs are able to audit the course. That is really meant to be our version of the practicum program that Linda mentioned. So this is a credit-bearing course where you're really learning kind of the key aspects of managing early-stage academic innovation. We have a module on intellectual property protection, on technology evaluation, and then really on kind of forming commercial partnerships. So it's a part lecture didactic course, but really you're working with actual invention disclosures within the Wall Cornell portfolio and getting hands-on experience. So this is offered now just in the spring. If you're interested, please reach out. Next slide. So now we're kind of start to give a little overview of some more detail of some of the things Linda mentioned. Next slide. So it starts with, the fundamental concept that intellectual property that's developed by, anyone within the course or scope of their employment obligations to Cornell University or using funds, facilities, or resources is owned by the institution. And the reason why we do that is that, the goal is for the university to protect and commercialize that innovation for the public good. Oftentimes there will be a financial return that will come to the institution that is shared with the inventors and contributors of that intellectual property. And we do this as, really a tool to recruit and retain top faculty and students, increase research sponsorship, and create closer ties to industry. But really, it's so that the research that's happening at Cornell can have a tangible impact on society. And there's no financial risk to anybody working with CTL, right? So all of the financial burden of intellectual property protection and commercialization activities is borne by the university. Next slide. And the reason why this exists, our downstream goal is for that impact, but it was really in response to the passage of something called the Bayh-Dole Act in 1980. And it was called by The Economist, which if you're kind of read financial newspapers is a very conservative news outlet. And they deemed it possibly the most inspired piece of legislation to be acted in America in the past half century was the Bayh-Dole Act. So prior to the passage of the Bayh-Dole Act, the federal government owned all of the intellectual property that arose through federally funded research. And there was the realization that there was less than 5% of the 30,000 patents that were owned by the federal government were actually licensed to commercial entities who were doing anything with it. And so there was this realization that there was all this innovation that the US taxpayer had paid for, but nobody was really developing it into products. And they said, you know what, let's give control of that back to the institutions where these innovations were made, and maybe they can do something with it. And I think that's what we've seen. So on the right-hand panel, you see just a lot of numbers around kind of jobs created and patents issued and inventions disclosed, but some really impactful numbers. There's been over 13,000 startups that have been formed on the basis of university on intellectual property that arose from federally funded research. And one, working here at Wall Cornell that I think is really an impactful number is that there's been over 200 drugs and vaccines that have been developed and are on the market benefiting patients and society since the passage of the Bayh-Dole Act. And prior to the passage of the Bayh-Dole Act, there was, not many therapeutics that were on the market that could trace their lineage to federally funded research, partner with a commercial entity, and a product benefiting society. So really impactful. So that's why we kind of do what we do here. Next slide. Next slide. And so these are just some Cornell innovations that have had societal impact, meaning they're innovations that were developed at Cornell, likely from federally funded research that were partnered with commercial entities who then took that all the way through commercial development and products on the market. And they really touch basically every industry vertical, right? So, you have crop sciences with lots of apples you eat come from Cornell University. I'm a Cornell undergraduate, so, I love my Cornell apple orchards. I still have my Cornell apple orchard bag. Rootstock, that has really kind of powered kind of food science, as well as diagnostics, advances in biotechnology, therapeutics, and high tech things like software and semiconductors and chips and things like that. So really impactful across all industry verticals. And really the message there is no matter what area you're conducting research in, there is an outlet for that if it can be developed into a product. And we're really interested in working with you across all of the industry verticals. Next slide. So I mentioned the Bayh-Dole Act. So nothing comes free in life. So, for the right of having the right to own the intellectual property and federally funded research, we have obligations to the government. And that really drives a lot of how we structure our relationships and how we look at commercial partnerships that make us a little different than if we were just a company who owned IP looking for partnerships. So we have an obligation to try to commercialize and protect federally funded inventions. We have a preference for working with US-based companies. We have a preference for small businesses over large, and this really gets to one of the fundamental purposes of the Bayh-Dole Act was also to drive economic development. And there are US manufacturing requirements. Another interesting piece is that we are actually obligated under Bayh-Dole to share a portion of revenue with the inventors and the contributors of the IP, and that's governed in our IP policy. So a third of all net revenue that the university collects from commercialization of intellectual property goes to the inventor pool. So there's some personal financial benefit even outside of the goal of just impacting society. Because of these obligations, we have to report the invention to the government. So it's important when you disclose to us to let us know if a federally funded research grant led to the invention or was used as part of making the invention. And the government also retains certain rights in the invention, and we have to flow down those obligations to any licensee. Next slide. And I'm going to pass this on to my colleague, Bill Pegg, to talk a little bit in more detail about intellectual property and what that means and how we view it.
Okay, thank you, Lisa. Next slide, please. So this is the overall technology commercialization process in CTL. I'll focus on the left-hand side. Martin will speak a little bit later as to the right-hand side. And this process overall represents a multi-year interaction that our innovators have with CTL. So on the left, obviously, starts with the research and ideation, followed by the disclosure of the invention to CTL. If in doubt about whether or not an invention is sufficiently developed to disclose to CTL, please reach out to the BD, such as Martin, to start a conversation. Sometimes there isn't sufficient data or sufficient innovation yet to warrant the invention disclosure, but it's better to reach out sooner rather than later. Evaluation. Once the invention disclosure is submitted, we will evaluate it, see if it is sufficient for our understanding of what the innovation is and what we should be doing about it. And we will start a dialogue or continue a dialogue with the inventors to help draw out additional information and understand exactly what it is we are working with so that we can best determine how to protect it. Protecting it would generally be filing a patent application on it patent application of one form or another, which we'll get into. And throughout that process of protection, it extends for years. And I'll get into that later as well. But this is something that will require many discussions, many contacts with CTL going forward. Next slide, please. So IP covers many, many different things. Here's a list of some examples. it touches every area of technology. So I won't read through the slide, but it's very expansive. And significantly, Cornell researchers do a lot of research that has a significant impact, that can have a significant impact on society. So we want to make sure that it gets that all of the work that is being done gets disclosed to us so we can help figure out how to protect it and how to commercialize it. Next slide, please. Types of intellectual property. In general, we deal with patents, trademarks, and copyrights. We don't really deal with trade secrets, but I'll discuss the other three. Next slide, please. So patents, what is a patent? It's a legal monopoly that's granted in return for public disclosure of an invention. The founding fathers abhorred monopolies. However, they recognized that if a monopoly were to be granted for a limited time, it would prompt inventors to actually disclose the invention to the public so that the public would be able to then build on that knowledge to hopefully create even better technology. The patent gives the right to exclude others from practicing the invention. It doesn't necessarily give the assignee or the inventors the right to practice the invention, because the invention could actually be covered by prior patents where the current patent is actually an improvement or an addition to the earlier technology. So it's possible that prior patents could still be controlling. So it doesn't give you the right to practice necessarily, but it does give you the right to exclude others from practicing your invention. It is only enforceable once it's issued. While it's pending in the patent office as an application, it doesn't really have any legal effect. So only after it is issued as a patent can it then be enforced. Patents are valid from 20 years from the application date. So just trying to think of how much detail to go into. I'll keep it very superficial. Basically, once the application is filed, it has a limited shelf life. The patent prosecution will often take a number of years, which will then leave a certain patent term available for commercialization and enforcement. To maintain the patent, to maintain it as a viable piece of intellectual property, maintenance fees have to be paid at intervals following issuance, at basically the 4-year, 8-year, and 12-year point. So that if those fees are not paid, then the patent lapses and goes into the public domain for anyone to practice. Inventorship is legally defined and it is distinct from authorship. So in this example off on the right, it lists a number of inventors. The inventorship is determined by the claims at the end of the patent. So it is the invention itself that determines who is to be listed as an inventor, not contributions. So there could be non-patentable contributions or patentable contributions. Next slide, please. So copyrights protect original works of authorship fixed in a tangible medium of expression. So what it does not protect are the functional aspects of something. So it doesn't protect the functional aspects of a computer program, the algorithms, formatting, functions, logic, etc. It merely protects the expression of that work and derivative works from that. So and data itself is not copyrightable, but an arrangement or selection of data can be protected. Next slide, please. Trademarks can be any word, phrase, symbol, design, combination thereof that identifies the origin of a particular good or service. So it's a designation of not only what that good or service is, but also where it is coming from, who is providing it. There are standard word marks or character marks, which is just the capital letters of a word. So that's a word mark. And then there are logo marks or special form trademarks, which are stylized. They can be black and white, they can be color, there can be words associated with them as well, juxtaposed next to the logo. So those are just some examples of trademarks. Next slide, please. So what is patentable? There are a number of statutory provisions that limit what can be or cannot be patented, and they're very generally stated. So Section 101 says subject matter to be protected is limited to one of four statutory categories: new and useful process, machine, manufacture, or composition of matter. That's extraordinarily broad, and there have been cases in the courts where they've interpreted that and limited that. So the judicial exceptions state that laws of nature, products of nature, abstract ideas, or natural phenomena cannot be patented. I highlighted the abstract ideas in red because that's currently a very contentious area of law to determine what is or is not an abstract idea. And it's much more inclusive than you might imagine. Next slide, please. Two other provisions. One is novelty, Section 102. And basically, you can't get a patent on something that has already been done before. It requires basically a one-to-one correlation. It needs to be exactly the same. So if it's been done before, obviously you can't get a patent. Section 103, obviousness or non-obviousness, basically says that a person of ordinary skill in the art would not reasonably have been expected to have modified or combined known prior art to arrive at the claimed invention. So in prosecution in the patent office, an examiner can apply multiple references and combine aspects of the different references and assert that the claims that we are trying to get in the application are obvious in view of combinations of the prior art, and that a person of ordinary skill in the art would have been motivated to make particular combinations. So it requires a fair amount of argumentation in the patent office to convince the examiners that something is not obvious in view of the prior art. Next slide. 112. So that's a statutory provision that basically sets forth the sort of the quid pro quo that the government expects in exchange for granting of monopoly rights. So I mentioned before that in exchange for the monopoly, the grant, the government wants the patent to describe the invention sufficiently so that others, when it's publicly disclosed, that others can make or use the invention, and that they can basically learn from that to create other inventions. So the written description of the invention has to be sufficient to actually enable, which is the second provision, enable the people skilled in the art to make and use the invention. The third category or criteria is the best mode. You can't, in the disclosure, you can't hide the ball. You can't keep the best way of doing something secret, publicly disclose lesser ways of doing something, that could result in invalidation of the patent. So you have to describe everything very thoroughly so that people can actually learn from the invention. Next slide, please. Types of patents. Generally, provisional patent application is what we start with. It's a way that we can get something on file quickly. There are no strict form requirements. It's not examined. It's a placeholder. Nobody looks at it in the patent office, and it automatically expires after 1 year. One caveat is that the priority date that's accorded to it is only as to whatever is disclosed sufficiently to enable a person of ordinary skill in the art to actually make or use it. So the written description is still of significance, and it could be challenged in the future if the patent is ever litigated. Non-provisional and patent cooperation treaty applications, those are the formal applications that we would spend a great deal of time on working with the inventors. We would file it within 1 year of the filing date of the provisional application to get the benefit of the priority date of the provisional application. And again, it must fully describe the invention in sufficient detail to enable a person of ordinary skill in the art to make or use the invention. Next slide. This is just an overall timeline of the process of preparing and filing an application in the lifespan of the issued patent. So on the left, conception, submittal of an invention disclosure form. Typically, when possible, we perform a prior art search to see if there's anything out there that is the same or similar to give us an idea of what sort of claim scope we might expect. Or if there is something out there that's the same, a 102 novelty issue, then we wouldn't file. Typically, we then file a provisional application. Within 12 months, we'd file a regular application, which would be a PCT or non-provisional. Patent prosecution generally takes roughly 2 to 5 years. There would be a number of iterations of rejections from the patent office. We would then review and respond to that rejection. We would advance prosecution to a point where we would be able to either get it allowed or not. We'd pay the issue fees, get the patent issued, and then I mentioned the remainder of the time left would be the term of the patent up to the 20-year point, where we'd be filing maintenance fees periodically to keep it valid. Next slide, please. This is a very generic illustration of sort of the increasing cost over time. So for the CTL assessment and up until filing of an application, obviously there's no hard cost, but once we start engaging outside counsel to prepare an application, the cost starts going up. So there are a number of, it's more steps instead of a continuous, but so the provisional filing, let's say ballpark might be $3,000 to $5,000. PCT filing might be $15,000 or so. And then we get into the prosecution where we get all the office actions and other things that we have to address in the various patent offices. So the cost just goes up and up and up over time, including the maintenance fees that I mentioned to keep the patent pending or patent valid. And the cost over time for a patent can easily be $40,000, $50,000, sometimes higher. So there's a significant cost associated with each patent application that CTL files. Next slide, please. I mentioned before, inventorship is different than authorship. It's a legal determination that's analyzed in view of case law and whatever the particular facts are that are presented. The inventorship is specifically defined relative to the claims of the application. So if the claims of the application change during prosecution, the inventorship can change. So initially, let's just say you have 10 claims for a method, 10 claims for a system. There's a restriction requirement which forces us to only go with the method claims, not the system claims. The inventorship might change due to that. And then if a divisional application is filed later for the system claims, that inventorship could be different as well. So just something to be aware of, inventorship can change during prosecution, and it's not based on contribution, well, I mean, I guess it is based on contribution, but it's based on the contribution to the conception of the inventions that are claimed in a particular application. Merely assisting the development of the invention, being on a team or supervising a team, does not automatically make a person an inventor. The contribution to the claimed invention, the conception of the claimed invention, would need to be something more than just a contribution of a well-known concept or the current state of the art. So there is a sort of a threshold that has to be crossed, and it's not just participation in a team. Next slide, please. These are the Cornell policies relating to IP. Primarily, we look at policy 1.5, inventions and related property rights, which would be like, in terms of related property rights, often that would be like computer coding that could have value both as a copyright and as a patentable invention, potentially, as opposed to 4.15, which is just copyright. Next slide, please. This is a really important slide. Public disclosure can jeopardize patent rights. So there's something called absolute novelty that exists in other countries. In the US, if there is a public disclosure, there's still a grace period where we can file a patent application within 1 year and we don't lose rights. However, in the rest of the world, if there is a public disclosure prior to the filing of a patent application, you are no longer able to get rights in other countries. It's a prohibition. So referring back to the slide of the CTL and what we do and what Martin will be talking about, we try to market and commercialize. Many inventors actually want to create startups. If there is a public disclosure prior to the filing of a patent application and you lose the ability to file patent applications in the rest of the world, that can significantly limit the value of that intellectual property. So it's critical that prior to any public disclosure, you at least engage in conversations with CTL to let us know of the public disclosure as early as possible so that we can start figuring out how to protect the invention. So what is a public disclosure? Well, a manuscript publication, preprint postings, particularly stuff like bioRxiv, published abstracts, open thesis defense would be a public disclosure, posters, talks, awarded federal grant applications, speaking engagements, social media postings. So anything that is a disclosure to the public that is not controlled, such as through a non-disclosure agreement, would be a public disclosure and would very likely limit the ability to file the application broadly, which would then impact commercial value. Next slide, please. Okay, with that, I will then turn it over to Martin.
Thanks, Bill. Yeah, we can go to the next slide, please. But I think before I move on, seeing that we're coming up against the hour, maybe I should ask if anyone has questions. Maybe particular people who need to leave at 1 o'clock. Maybe we should turn to those first. I see some questions came in via the chat, but if anyone wants to speak up, feel free. Otherwise, I will continue. Looks like I can. Yeah. So, how do you really get started with your interactions with CTL? Formally, it does start with what's called the invention disclosure form that we will ask you to fill out. But as others have mentioned before, you should not be shy to reach out to us way earlier as you are working on your ideas and doing experiments in the lab. we can work with you and we want to work with you to figure out when is the right timing, when is your project really ready for consideration, whether it can be patented or otherwise turned into commercial opportunity. Next slide. So and in our assessment of your invention disclosure, we really look at ultimately the goal is to see if we can help translate your science into commercially viable products, right? And so we look at the invention, we look at the technology. We were certainly not scrutinizing the science because we wouldn't be really capable, and that's not really necessary for us. What we really look at is how can the technology be protected and how can it be turned into a potentially viable product, and what are the steps necessary to move that technology from the lab bench to a commercial activity. Next slide. So we ask many questions, and this is just a sort of a high-level selection of questions we ask. Many of them really go towards both the assessment of patentability and potential claims, as well as what the likely products or services could be that could be enabled by your invention. They kind of go hand in hand and are really related. If we are thinking about patenting, we of course also want to think about, as Bill mentioned, the patent doesn't necessarily give you the right to practice your own invention. You can exclude others from practicing your invention, but if there are, the word is dominating patents out there, right, that you don't have rights to, you could still be blocked from practicing your own IP. So freedom to operate comes into play. And also, even if we think we could get a patent, the question is, how could you even detect if competitors are infringing on your patent? So a patent may not necessarily give you enough competitive advantage. And there are obviously a host of other topics to be discussed, depending on what the technology and the relevant marketplace is. Next slide. We talk about customers, right? Who and what's the product? What's the value chain in the particular market segment, and who might be the decision makers when it comes to make or buy decisions, right? And who do you really need to convince of your value proposition, and what is your value proposition? Obviously, market size. We deal with inventions and businesses that capture a range of market sizes, but certainly when it comes to, Bill talked a little bit about the investment in patents. Obviously, if we have a good sense of a market being just very sort of a niche area where the market might just not be large enough to even justify the expense of a patent, those questions all come into play as well. And most importantly, of course, who are the commercial partners we need to find and reach out to and connect with? And if you can go to the next slide, please. We're already over time, so this slide talks a little bit about sort of what is needed to bridge that gap between the lab bench invention and ultimately some commercial activity. And how can the university, how can CTL, Linda talked about the Ignite gap funding program, how can some of that help bridging that gap to make technology perhaps more attractive to industry partners or investors? Next slide. We do a lot of outreach, marketing, if you want to call it that. We prepare marketing material, marketing collateral. Again, always focusing on not so much on what the science is, but really see if we can emphasize the potential value proposition to industry partners and companies, and what's the pain point that we think the invention, the technology can really help solve. Yeah, we do this through many different platforms, direct emailing, social media. We have strategic partners we tend to re-engage with, where we can gather feedback and input. SIVA, the event series that Linda mentioned, is a very helpful tool for us, and of course we're always interested in connecting with alumni and the larger Cornell and Ithaca and New York City venture and business ecosystem to try to make connections. Next slide. As an inventor, you should also be thinking as a salesman, if you will, right? We hope that we can partner with you in that area as well, where you can help us spread the word amongst the contacts you are making and the network you have. So I will stop there. I know we're over time a little bit, but questions have come in. I noticed. Is there any? I couldn't keep up with questions now. Is there anything urgent that we want to address now? Anyone who wants to speak up?
I believe Lisa has addressed the question. And regarding the recording, yes, we'll share with you the recording along with the slides. And here we share with you how you can reach out to us. There are office hours. You can reach out to any of us. You'll have in the slides our contact information. Reach out to us, engage with us, the office hours. If you want to talk about your ideas or you are more further along, reach out to us, to one of the licensing officer, to myself, if you want to learn more about Ignite and how you can de-risk your technology through the grant or through the Ignite Fellow Acceleration Program. You have the incubator directors on campus that are a great resource if you are considering venture creation as well, and you are related to Cornell and doing research at Cornell. And next slide for the survey, because we want to hear from you. So we want to hear from your ideas. You want to hear what you think about the content of this presentation, or also the next lab to impact. Do you want to hear more about the IP in terms of module, more about healthcare, more about commercialization strategy and ventures, or social science? Let us know. Take this 45-second survey to share your feedback about today's event, but also the next one, the topics you would like to hear about, learn about, because here it's about educating and learning about the commercialization journey is a different step, but also the different what we have in the ecosystem to help. The tools are available, the support is available. Anything, maybe in the team, if you have anything else to add, and we are welcoming any question as well.
I think we're good. Yeah.
Okay, great. Thank you, everybody.
Thanks, everyone. Thanks for attending.
Don't hesitate to reach out anytime.
Thank you. Bye.
Bye.
I know.